Tonight on the Daily Debrief, a settlement in the case of a billionaire accused of trafficking underage sex crimes victims. Are more criminal charges possible?
There is absolutely no justification for the broad scope of immunity that was granted in this case.
Now Congress might act.
We put a sex offender back on the street.
Plus, the case of 3 Chicago cops accused of covering up a murder. That's on tonight's Daily Debrief for Tuesday, December 4th. Good evening, everybody. An update to breaking news we first brought you on the Law and Crime Network earlier today. A settlement in a civil case involving a billionaire financier with connections to 2 U.S. presidents and underlying accusations of sexual assault involving underage girls. The billionaire, Jeffrey Epstein, filed the case against attorney Bradley Edwards, who was representing some of the women who accused Epstein of a series of assaults. Jury selection was supposed to begin today, but the settlement comes along with a statement by the billionaire admitting questionable reasons for filing the counterclaim in the first place. The big question tonight is whether criminal charges could follow against Epstein. Epstein released the following statement about the attorney he was battling. He said, "While Mr. Edwards was representing clients against me, I filed a lawsuit against him in which I made allegations about him that the evidence conclusively proves were absolutely false. The truth was that his aggressive investigation and litigation style was highly effective and therefore troublesome for me. The lawsuit I filed was my unreasonable attempt to damage his business reputation and cause Mr. Edwards to stop pursuing cases against me. It did not work. Despite my efforts, he continued to do an excellent job for his clients, and through his relentless pursuit, he held me responsible. I'm now admitting that I was wrong and that the things I said to try to harm Mr. Edwards' reputation as a trial lawyer were false. I sincerely apologize for the false and hurtful allegations I've made and hope some forgiveness for my acknowledgement of wrongdoing." That statement from billionaire financier Jeffrey Epstein about the lawyer he was attacking. Law and Crime Chief Investigative Correspondent Brian Ross is back on the Debrief tonight. Brian, you've been following this case for some time. This statement is basically Epstein saying he's a bully in this case.
Absolutely, and it raises lots of new questions. It does not put this to rest whatsoever.
This statement almost sounds like it was written by the prevailing counsel as part of a settlement, saying, well, I'll agree to drop it if you issue this statement saying I'm a good guy after all.
That's right. Epstein did not show up in court today, Aaron, to read the statement himself. He had one of his lawyers do it instead. But outside the courtroom, Bradley Edwards, the lawyer involved here, took a victory lap again and again, essentially saying, Epstein lied about me. He now has admitted it. I'm going to go full speed ahead to continue my campaign to get justice for the underage girls who were Epstein's victims.
So the statement settles the counterclaim. It accomplishes that. Is there anything that it accomplishes in addition to that, and is there anything that it does not accomplish?
Well, what has happened in the last 2 weeks is a blockbuster investigation by the Miami Herald, which revealed all of the secret dealings behind the scenes between Epstein's high-powered legal team and the U.S. attorney at the time, who's now the Secretary of Labor, Alexander Acosta. And it raises lots of questions about that deal, with new calls now for another investigation, and perhaps some are saying new criminal charges.
There are so many layers to this case, we're going to start breaking them all down now. Upon learning that Epstein was backing down, attorney Bradley Edwards released this.
It's taken a really, really, really long time to get here, but now we're past the sideshow of what was allegations Jeffrey Epstein made against me, that he's now said were categorically false. We can focus now back on the people that we care about and who need our help. That's our clients. After today, we're going to have a volume of victims that are going to come forward and be ready to testify and not get cross-examined. Testify about what happened to them in a way that will help them heal.
Edwards says this is the tip of the iceberg. His clients accused billionaire Epstein of a lot of illegal conduct, but their complaints remained in state court mostly, and Epstein received a sweetheart deal from the local U.S. attorney, Alexander Acosta. Bradley Edwards is attempting to reopen some state proceedings while also pushing for federal charges.
Who knows what else is going to come out? I mean, the excellent journalism has spread the message. It's not just a state court case that's stuck in Palm Beach County now. People are really aware of what's going on. And there were times where people were aware, but were also scared to do something about it. So everybody's coming forward, and it feels like there's no more fear. Even if we were to win on the Crime Victims' Rights Act case, which our feeling is we should, if we invalidate that immunity deal, that doesn't mean the U.S. Attorney's Office has to charge him. They could enter into the same deal. It just means that they would have to speak with the victims first and actually afford them rights this time. They have prosecutorial discretion. But the focus of attention on this is going to make it more difficult for the government to want anything but an appropriate prosecution. Okay, that's all that we can do. We can't, let's say new victims come forward. Let's say it's in California. There would still need to be a prosecutor in California that wants to prosecute this case. And everybody can go around asking, why is it that nobody, no U.S. Attorney's Office has ever wanted to prosecute what looks like a very, very strong case against a very powerful political person.
Another attorney in this matter explained why additional criminal charges against Epstein in Florida's state courts would be extremely difficult at this point, and why other states and the federal government might be the key to moving forward.
We are dealing in Florida with a restrictive statute of limitations. It would be very difficult at this point, if not impossible, to bring criminal charges arising out of conduct that occurred more than a decade ago. There are jurisdictions where that problem is not faced, but Florida is a jurisdiction where we face statute of limitations concerns. However, there very well could be the possibility of prosecution at the federal level based upon the illegal plea bargain that was entered into.
Let's go back to Chief Investigative Correspondent Brian Ross tonight. So, Brian, this case is shaping up like a hydra. There are many heads moving around here, different courts, different states, different jurisdictions. How do we break it all down?
Well, I think you have to read through what's being said here. The tea leaves suggest they may have been able to find other victims where they were assaulted by Epstein and others outside of Florida. In New York, where he has a mansion, in the Virgin Islands, where he has a home, in New Mexico, where he has a home. If they find other victims there and the state laws there permit prosecution, this could be a new turning point in this case against Epstein. He could face new prosecutions in those states.
That'll be really, really interesting because, again, statutes of limitations are different in different states. A lot to keep track of in the many moving parts of this case. We're going to continue to listen to some more of what was said in this press conference earlier today. Complicating the case is the so-called sweetheart deal which Jeffrey Epstein received from the local U.S. attorney in Florida. That prosecutor, Alexander Acosta, has since moved on to become labor secretary in the Trump administration. Epstein is also connected to Trump as well, of course, to former President Bill Clinton. The attorneys handling the victims' cases had intense criticism for Acosta.
Jeffrey Epstein is not an unintelligent person. It would take a fool not to recognize that he faces extremely serious jeopardy at this point. He faces the distinct possibility that his sweetheart plea bargain can get set aside and that he and others will face federal criminal prosecution. There was a development this morning. I'm not aware of the complete details. It's been reported to me secondhand, but apparently an effort is being made in Congress to open an investigation with regard to the circumstances of how this plea bargain could possibly have been entered into. I've practiced law for over 45 years. The first 5 of those years were spent as a criminal prosecutor. I have never seen, I have never heard of a plea bargain in which not only the prospective defendant, but the defendant's named and unnamed co-conspirators were granted blanket immunity for unnamed crimes. That just doesn't happen. That's inexcusable. There is no reasonable justification, regardless of what kind of evidence Jeffrey Epstein may have been secretly providing to some other prosecuting authority. There is no justification for keeping this deal secret, for violating the Crime Victims' Rights Act that affords victims an opportunity to be able to address the court before any plea bargain is approved by a judge, and there is absolutely no justification for the broad scope of immunity that was granted in this case. That is deserving of the kind of scrutiny that Julie Brown began to focus on this case, and that hopefully the U.S. Congress will focus on this case as well. They can get answers that we can't get. So we're counting on that development as being very significant in terms of being able to ultimately bring Jeffrey Epstein to justice.
Of course, another big question tonight is what needs to happen to that former prosecutor, Alexander Acosta, who wound up in President Trump's cabinet. The attorney representing the victim's attorney refused to call for Acosta's resignation.
We have not yet heard the rest of the story with regard to Secretary Acosta. He certainly hasn't spoken. I am hopeful that the congressional investigation that is being spoken of takes place. We will get more of the story at that point in time. I'm not here to call for Secretary Acosta's resignation. I don't know all the facts. I know that the facts that are known demand further answers.
The possibility of a congressional inquiry appeared one step closer to reality today. The congresswoman who represents the area is forwarding this information to the Department of Justice Inspector General.
The current Secretary of Labor, Alex Acosta, gave a non-prosecution deal to a wealthy and well-connected serial sex offender, hid it from victims, and granted immunity to any potential co-conspirators who were involved in the crimes. According to recently obtained documents, the individual to whom the Secretary Acosta provided the non-prosecution deal was Jeffrey Epstein, who was facing a 53-page indictment that could have resulted in life imprisonment for trafficking minor girls for sex parties. Rather than pursue the indictment fully to ensure the individual could never prey again on minor girls, Secretary Acosta entered into an extremely preferential deal that resulted in the perpetrator of horrific crimes against children serving just 13 months in the county jail. The non-prosecution deal also had the effect of shutting down a Federal Bureau of Investigation examination of whether there were more victims, and astonishingly granted immunity to co-conspirators. As members of Congress intent on ensuring the equal application of justice and gravely concerned with the plague of sex trafficking and sexual abuse, we urge you to conduct an investigation into the circumstances surrounding the non-prosecution agreement Mr. Acosta entered into with Mr. Epstein.
To Brian Ross one last time tonight. So, Brian, what is the Secretary of Labor saying about all these accusations?
Well, this has already come up in Congress when he had his confirmation hearings for Secretary of Labor. And he said at the time he entered into the agreement because it's much harder to prove a federal crime involving transportation of women across state lines. And he thought that would be a flimsy case. But as the Congresswoman points out, the effect of his decision was to shut down the FBI investigation. More information could have come out, she argues, if the FBI investigation had continued. And in fact, the young women who are underage victims, they felt the FBI investigation was going on. They had no idea about the secret agreement until after it was made.
And this is where the Crime Victims' Rights Act comes into play, because that affords victims of crimes an opportunity to say something in front of a judge before the plea deal gets rubber stamped by the bench.
That's right, and clearly it didn't happen here, but because the plea deal essentially shifted the crime to state court, the federal government has argued, well, it doesn't really apply. Many disagree with that.
Interesting argument. Look, any sense of what the inspector might look into in this case if indeed the Inspector General at the DOJ agrees to pick up an investigation?
They'll start with, did the U.S. Attorney Dan Acosta follow Justice Department guidelines? The argument is he certainly didn't in terms of keeping the victims informed. Was there any untoward influence, politically or financially, against Acosta? No allegation of that effect, but that's one of the things they'll certainly look at. And they'll want to know from Acosta, why did he make this deal? Why did he work so hard to keep it secret? Some of the documents that have come out in the Miami Herald investigation suggest a conspiracy by all the U.S. Attorney's Office to keep this very, very quiet.
Well, we know you're going to follow this. The congressperson said that if the DOJ Inspector General doesn't act, she'll take it up with appropriate committees. So this could just keep going and going. Chief Investigative Correspondent Brian Ross, we appreciate your insights.
Good to be here.
All right. Let's move along now to some other information about this case that we're covering. Epstein's famed former attorney, Alan Dershowitz, spoke to Law and Crime today to deny accusations that he also had sex with one of the purported victims in the Epstein case. He thinks the victim should be punished.
The goal of going after me was to get a lot of money from Leslie Wexner, who was accused of the same thing. They accused me publicly, and then they accused Wexner privately in an attempt to get some money from him. But and the best friend told me that Virginia Roberts told her she was, quote, she felt pressured to include me, even though she had never previously mentioned me as one of the people with whom she allegedly had relations. So my case is completely closed over. I've been completely cleared. I had nothing to do with it and never met the woman. And this is a woman who should be seriously punished for having submitted false information and a false affidavit.
Still ahead tonight on the Daily Debrief, the state is close to resting its case against 3 Chicago cops accused of covering up a deadly officer-involved shooting. Plus, newly released video shows the Colorado man who admitted to murdering his family getting very, very nervous. Find out why after the break. The prosecutor who obtained a confession from the Colorado man who admitted to killing his wife, his daughters, and his unborn son is releasing videos related to the case. Chris Watts was caught on tape by a neighbor whose doorbell camera captured images of Watts disposing of the bodies of his wife and children. Here, Watts reacts with nervous surprise and some would say fear upon seeing the footage in a neighbor's house. At the time of this video, Watts was still claiming his family had just disappeared. The prosecutor also released this police body camera video of Watts being arrested. Watts pleaded guilty to a series of crimes in return for a life sentence. The guilty plea, of course, allowed him to avoid the death penalty. Watts has reportedly been moved to a prison outside of Colorado for safety reasons. Time now for a check of criminal incidents making headlines with Anthony Velez.
Here are today's top crime stories trending on LawandCrime.com and across the country. Investigators in Louisiana arrested 3 teenagers for reportedly killing a woman with her own vehicle as they carjacked her. The victim, 49-year-old Jeanette Franco-Plessy, was forcibly removed from her car and fatally struck by the suspects, 17-year-old Jontrell Robinson, 18-year-old Edwin Cottrell, and a third unidentified teen. Plessy's son-in-law unsuccessfully tried to stop the carjacking before the teens reportedly reversed the vehicle and ran over Plessy, who died later that night. The teens now face multiple charges, including being a principal to second-degree murder. Investigators in New York are searching for a missing 14-year-old and the man they believe kidnapped her off the street. The victim, Joanna Coates, was reportedly abducted by 41-year-old Robert Gonzalez in Rochester on Saturday. Authorities believe Gonzalez may be traveling to New York City with the teen. Investigators reportedly are in contact with other departments down in the New York City area regarding Coates' disappearance. A woman in Michigan accused of fatally crushing her boyfriend with her body pleaded guilty to third-degree murder. 44-year-old Wendy C. Thomas reportedly attacked and crushed her crush, 44-year-old Keno Butler, at the couple's apartment in Erie. At the time of the attack, Thomas reportedly weighed in at over 300 pounds, while Butler weighed 120 pounds. As part of the deal, Thomas will serve 18 to 36 years in state prison. A man in Colorado on trial for the execution-style killing of a teen pleaded guilty to second-degree murder. 23-year-old Joseph Michael Lopez was sentenced to serve a maximum of 48 years in prison for the execution-style killing of 19-year-old Natalie Bollinger, who he claimed hired him off of Craigslist to kill her because of reported relationship issues with her boyfriend. Lopez was also ordered to serve 5 years of probation following his release from prison. Those were today's top crime stories. I'm Anthony Velez for the Daily Debrief.
New developments in the case of an alleged cop cover-up in Chicago, Illinois. It all surrounds what happened in this video, which shows Chicago police officer Jason Van Dyke shooting and killing a knife-wielding teenager named Laquan McDonald. One jury convicted Officer Van Dyke of second-degree murder, but now 3 other officers are on trial. The 3 men are accused of conspiracy, official misconduct, and obstruction of justice. Prosecutors say they lied in their official reports by claiming Laquan McDonald attacked the officer who shot him. Of course, the video contradicts that. There are some live arguments happening in this case right now on the East Coast here on the Daily Debrief. Let's listen in to a defense argument that the judge should dismiss the case after the state's case in chief.
And then we have Earl Briggs. Again, over our objection, respectfully, Earl Briggs is allowed to testify. Why? Why? If Dora Fontaine and the evidence in this case was so great, the state wouldn't need to put on Earl Briggs. That is a red flag to you, Judge. Hey, Judge, our case states we're going to put on this medical examiner, quote-unquote, investigator. And what does he say? He says he's taking a phone call from somebody who claims to be David March. All right. And this person, David March, tells him, among other things, that McDonald lunged at the officer. Really? Okay. Well, how about Mr. Briggs taking a note? Are we asking that? Are we asking too much for this guy who's sitting behind a desk in his midnight shift who won't go out to the crime scene? Is it too much to ask Mr. Briggs to write down a note? Because he did it. Yet the state wants to use Dave March's notes against Dave March. Not fair. But again, let's talk about Earl Briggs. He wants this world to believe that that report that he stands by, all of it came from Dave March. That's a crock. Why? Well, there's another report that he doesn't want to acknowledge, which shows that that report was changed. There's something funny going on at the medical examiner's office with Earl Briggs' name all over it. That report was changed. And Briggs wants to tell this court that from his desk on the phone with David March, he's rereading. He's reading over to Dave March what March just told him. And that would include words like on or about October 19th. First of all, it's the wrong date. But neither is it may. On or about, those are words lawyers use. All right? For Briggs to say that's exactly what Dave March told him is a crack. Briggs got the wrong beat number. He got information that Dave March could not.
These arguments have been heated throughout this case, and our live coverage of it will pick up tomorrow. If you'd like to watch today, you can continue watching on Law&Crime.com. Our live coverage begins tomorrow at 9 a.m. For now, this is Aaron Keller. Have a good evening from all of us at Law&Crime.